In Wealth Protector TV. Really fired up for this episode. Got Brad Barth, who is a top asset protection estate planning attorney across the country. Brad is in high demand for his talks everywhere, to Vistage International, the Women Presidents Organization, and the San Francisco Apartment Association, and on and on and on. And so Brad partnered here with the American Apartment Owners Association, the largest national association for rental income property owners in the country. And Brad pulls the curtain on guarding your property using proper estate planning. And there's a lot of changes going on in the estate planning world. New taxes, new rules, new laws. And so jump on over. You're gonna love this. Grab a pencil and paper, take some notes. Let's go check out Brad.
Welcome to the webinar, and thank you for joining us. I am thrilled here to have Brad Barth, our speaker. Before we get started, though, I do want to just point a couple of things. One is, for those of you who've been on these webinars, we always send you the recording. I was just talking to Brad right before this, and Brad says this is going to be a packed hour of information. Yeah. So you can't write down, you can't remember it all, it's okay. It's going to be sent to you, and Brad will probably share the slides too, so don't worry about that. And for those of you who don't know Brad yet, he's been with us a few times now. Now he's a regular with us on matters of estate planning now for this topic, but he's also some asset protection and information about coronavirus as well when we really needed that information. So thank you so much, Brad, for coming on today. I'm really thrilled to have you, especially because we haven't covered this topic ever. And I think it's extremely important. And it came up in our coronavirus discussions. A lot of people are looking at their estate planning now. And I think it is a good time to look at it and review it. And you have a lot of knowledge that we can tap to specifically for rental owners. So one last thing before I hand it off to you, Brad, for those of you on the call who have questions, I'm sure there will be many, go ahead and put it in the question and answer box so that I can ask those to Brad after he's done. It is going to be about an hour, and then we're going to do Q&A. So try to stick around as long as you can and put in your questions when you have them, and we'll review them at the end. So with that being said, take it away, Brad.
Great, Alexandra, thank you very much. And it certainly is a pleasure to be back here with the American Apartment Owners Association. And yeah, this came up. We were doing a conversation, a webinar regarding landlord issues and COVID matters. And I said, well, this is a definite wonderful segue into doing a talk on estate planning. So Alexandra worked with my office, and we kind of got this on tap here. So one of the things that I find is relevant when it comes to estate planning is to understand at least who you're talking to and what's the perspective that I bring to estate planning. I've been doing this work for about 22 years, and I got my start as an estate planner, and then I kind of moved and I kind of advanced through those areas where I wound up doing trust and estates administration. And that basically is when somebody passes away or somebody becomes incapacitated, somebody has to pick up the documents that you drafted and actually implement them. I'd say that's where the rubber meets the road. So I have a lot of experience in the administration side. I also deal with litigation. So when the kids are fighting about inheritances, or they're fighting about the piano, or you're fighting about a fiduciary, a trustee who's not being all that friendly, I also do the litigation side of trust and estates. And then lastly, I'm also a professional trustee. And so for those that have either nobody in the family that they really kind of trust to do the job, or they're just concerned about creating a civil war among the kids or siblings, then they want kind of like a neutral third party, somebody who understands what the responsibilities are. I also serve in that capacity. So when I give my talks about estate planning, I'm not just sitting here philosophizing about who should get your stuff when you pass away. I come to this from a very practical point of view, from a drafting, administration, litigation, and from a trustee's perspective. So I think what I deliver in these types of presentations are not the what can I do through my estate planning, because you can pick up any book about that, but moreover the what should I do, right? The coulds versus the shoulds is a big difference between, I think, working with an experienced planner and working with one who basically may not be as familiar with this area. So I kind of have a subtopic here called protecting and enhancing your legacy. And I kind of what do you call it? Shrunk this presentation down to specifically address some of the real estate matters. So let's take a look at what's on the agenda for today. All right, so I went ahead and just talked about the need for estate planning, some of the benefits and scope. We'll talk about probate, especially for those of us that have real estate. Probate is going to be a really, really big deal. And of course, I'll be giving you planning tips throughout the course of the hour. Again, you can't talk about estate planning without talking about taxes. They say there's two certainties in life, death and taxes, and that's kind of what we're talking about. So what is the impact of the Trump tax cuts that became effective of January 1, 2018. That's also a very important date that we note, because we have people that have drafted plans before 2018, and you'll see what type of changes may be effective as a result of that. We'll talk about some estate tax reduction techniques for those of us that do have large estates, either under the current Trump administration laws or what may happen in the future with a reduced estate tax exemption. Also with state death tax issues. Although I'm coming here from California, we do not have a state death tax, so I may not be familiar with all your individual state laws. So I'll be addressing the estate tax things from a federal level only. And also some recent developments and how that affects what are called inherited IRAs. And there was a question that kind of came up about the use of IRA-owned LLCs. That's kind of beyond the scope of an estate planning talk, but I certainly will address the use of an IRA-owned LLC within the inherited IRA environment. And also with the new Secure Act and how that affects your retirement plans, and what we used to be able to do as far as stretching out retirement plans, what do we now have to look at with regard to that type of planning? And then lastly, I always find it to be a responsibility of an advisor to always talk about charitable planning. And I'm only going to be talking about one of the tools, and I'm using this tool specifically because it's the tool that is most relevant to my property owners, and that's the use of a charitable remainder trust. Hopefully we'll be able to squeeze all this stuff in the next 55 minutes. So let's go ahead and get started. So I always want to start off with a definition. It's very important that we all acknowledge and know what it is that we're talking about. How can you talk about estate planning unless you know what comprises your estate? Most of us as business owners or as property owners have put together a personal financial statement for the benefit of a bank or for getting a line of credit or some business transaction. And so we're very familiar with like our house and real estate being part of our net estate, or our stock and business owners, or our personal property, and certainly our retirement assets. And also on a personal financial statement, you'll see the cash value component of a life insurance policy. But what typically is not listed is the death benefit value of a life insurance policy. So you can have a net worth of, let's say, $3 or $4 million, and then you have a $3 or $4 million death benefit of a life insurance policy. So for estate tax purposes, the estate is not 3 or 4 million. The estate is either 6 or 8 million, depending upon the numbers that we're using. In other words, the death benefit is included in the value of the estate for estate tax calculation purposes. And why is that important? Because whenever I speak with my clients, they're always saying that, well, I thought that the life insurance is tax-free. It's income tax-free to the beneficiary, but it's included in the estate of the owner. And that's very important, because although we're currently enjoying a very large estate tax exemption under the current Trump administration, we don't know what's going to happen in the future, whether it's going to be next year with a new administration or after a certain date of January 1st, 2026, and how the laws may change. So although you may not have an estate tax problem now, even with your insurances, you may have it in the future. So I want to make sure that you understand that inclusive of the estate for tax purposes is the death benefit value of a life insurance policy. And for a lot of my clients, that comprises the largest asset. They may have, their house may have a lien against it, a mortgage against it. They may have some money tied up in retirement, but they have millions of dollars of life insurance. So just make sure that you remember that that's part of your taxable estate. So one thing also, when it comes to real property owners, you got to know what probate is. And you always hear, have an estate plan and avoid probate. They talk about probate like it's some kind of 4-letter word. And the reasons why you want to avoid probate is primarily because of its lack of privacy. It's like any other type of court proceeding. It's completely available to see, who's getting what upon somebody's passing. And also just the time and expense that's involved in it. And every state is different. And one of the benefits of having traveled the majority of the states in the country, having given these types of talks, is that I know that states like California, estate planning is probate is very, very expensive because we go based upon percentages of gross estate. Whereas other places like Texas, for example, it's actually pretty inexpensive, mostly based upon or attorney's hourly rate. So there's a big variation between the cost of probates, but generally speaking, most people try to avoid probate, if not for the cost, certainly for the privacy. Because what we're always worried about is that there are unscrupulous people out there that want to sell assets, sell investments, sell real estate investments, or want to work with your beneficiaries because they just find out that little Johnny just inherited $2 or $3 million. And little Johnny may not have the financial maturity as to how to manage that $2 or $3 million. And I know this is a matter of fact because I, as the fiduciary, wind up receiving a lot of this correspondence from those folks out there, because they're going on the public records and finding this information. So we want to make sure that we use probate as a protective privacy tool, so we're able to kind of like keep those types of, I call financial predators, away from our newfound wealth with our beneficiaries. But also very importantly, when it comes to real property owners, is what's called an ancillary probate. So not only do you have the time and expense associated with probate in your own state, every other state where you own real estate, which is very relevant to our conversation here. I'm in California. If I own property in Nevada, Florida, Texas, and I pass away, well, guess what? I'm going to have a probate here in California. Now, California can only control the dirt within California's borders. So how do I then deal with Florida or Texas? Or in Nevada? Well, a California judge cannot control what happens in these other states. So you have to have another probate called an ancillary probate in all those other states. In my example, Florida, Texas, and Nevada, at the time and expenses associated with that state's probate rules. And I always give the example that probably one of the most complicated and most expensive probates I ever had to deal with was with a lady that passed away in Arizona. Their estate was wrapped up pretty quickly in Arizona, probably within 6 months or so, but she happened to have owned 13 parcels of property in Riverside, San Bernardino, and LA County. That took 3.5 years at my attorney's rate under the California rules in order to do a full administration. Very expensive and completely avoidable if she would have used a proper estate planning tool called a trust. And so some people say, well, I don't need to worry about probate, Brad. I have a will. And what's misunderstood about that is that although a will is an estate planning tool, it is not a probate avoidance tool. As a matter of fact, the only proper officer to actually read and implement a will is the probate court. So when you basically go to probate, it is proving up the will, that it was properly executed, et cetera, et cetera. So it's not a probate avoidance tool at all. It's actually a guaranteed admission ticket to probate. Well, then I get things like, well, my will creates a trust. So you're talking about trust. Well, my will creates a trust. I've nominated successor trustees. I appointed the beneficiaries. I gave all these separate provisions from it. Well, you've created what's called a testamentary trust that's arising up through a will. Well, if you took the time, effort, and energy to create it in a will environment, why not create it during your lifetime, fund it during your lifetime, given the option to continue to make changes during your lifetime, and completely avoid the court's assistance in creating that ultimate testamentary trust? So just again, one of those things that comes across a lot of times, I want to make sure that's addressed, that having a will by itself is not a probate avoidance tool. There are other forms of assets, however, that do avoid probate, and one of them happens to be joint tenancy. So there is a way of transferring assets without the need of an estate plan, without the need to go into probate. And things like joint tenancy, life insurance policies, retirement plans. Like joint tenancy, those assets go by whose name is on title of the deed. I call it whoever lives the longest gets the asset. It has what's called the right of survivorship. Things like life insurance policies and retirement plans, these have listed named beneficiaries. And so long as there is a named beneficiary and it's not the estate, whomever's listed as the beneficiary, they're the ones who are going to get the asset. So let's kind of explore this for just a moment. So joint tenancy typically is held between husband and wives in non-community property states. It's typically held between business partners, between siblings, between parent-child. And it's not only relevant to real estate. You can have assets that are held, bank accounts that are held in joint tenancy, for example. But the important and unique thing about joint tenancy is this bullet point right here called a right of survivorship. It's very simple. If you have two people who own a piece of property, and one person passes away, the asset vests automatically in the surviving joint tenant. It's not that the deceased joint owner's interest is inheritable or divisible down to their beneficiaries. No, it goes to the surviving joint tenant. That's what's called a right of survivorship. And so what happens here is that we wind up having unintended disinheritances. And I see this all the time. A couple of business people, siblings, they go ahead and they invest in a piece of property. They each put in $100,000. So their initial contribution is $100,000. The property then appreciates up to $1 million. And they're sitting here saying that, thank goodness, because if I ever were to pass away, I know that my family is going to have the income and the future appreciation or whatever of this particular asset. Unbeknownst to them, they went ahead and signed the deed as a joint tenant for whatever reason. It could be the advice from counsel, maybe the notary who came, gave them that particular advice without fully appreciating what just happened. So now when the first deceased joint owner passes away, the surviving joint owner files a piece of paper. It's called an affidavit of death of joint tenant. And when they file that, the property then vests in the surviving joint owner 100%. In this case, it's 50-50. If it's a third, then you just get whoever lives the longest gets it. And they have no obligation to give anything over to the deceased co-owner. Basically, you have that unintended disinheritance, which winds up being a disaster. We do use joint tenancy, don't get me wrong, but it has to be used purposefully and with intent. So here, a very simple estate plan. I have a good friend of mine who's a client, and he says, listen, Brad, my mom, she came here to California I'm the only son. She came here to be closer to the grandchildren. She has a house, and she has a small bank account that she's receiving Social Security on. Do I have to go through all of this of having an estate plan, et cetera? And his name is Darren. I said, Darren, the answer is no. We can just go ahead and put the mom's bank account in joint tenancy, put mom's property in joint tenancy, assuming mom passes away before you. All those assets simply vest over to you, and it's a one and done. Basically, it is an effective means of transferring assets without the need for a full estate plan. I also recommend these things as an administrative side pot. So what I mean by that is I just got done telling you that I'm a trustee. Well, as a trustee, I'm responsible not only for managing the assets of the trust and keeping those assets productive and protected for the benefit of the beneficiaries, I'm also responsible for all the liabilities, paying off the debts, the tax liabilities, etc. So you can assume that absent I getting a full inventory and appraisal of all the assets and all the liabilities, I'm not letting a single dollar out of my hands to the beneficiaries until I know I have a liquid estate. Because if I start slinging money to all the beneficiaries and then there's a tax bill, I become personally responsible for that tax bill. And it's going to be very difficult to go collect money from the beneficiaries once that money has been distributed, because typically it doesn't last very long in their possession. So I hold on the assets and don't make any early distributions until I've determined I have a liquid estate. And that could take 6 months, it could take 18 months. So sometimes knowing that we may have this type of challenge, we go ahead and say, let's take $50,000 and put it inside a joint account with the good son, let's just say. So while we're trying to figure out the administration, there's an immediate amount of money available to one of the kids, for example, to take care of final expenses, funeral expenses, hiring the lawyer, things of that nature. So we do, again, use it as an administrative side pot. We also use it in blended family scenarios or special beneficiaries. Sometimes you just don't, there are other reasons why you simply wouldn't want to have a child listed in the plan. Maybe it's a child that from a previous marriage that nobody knows about, for example. So you may want to have some way of transferring money over to them without them being listed in the actual estate plan. Again, there's different reasons for it, but again, it's another reason why we may use joint tenancy. So what we're worried about is these bullet points in red. Unintended disinheritances happens all the time. Unintended liability exposure, because again, as a joint owner, you own the assets 100% each in two people. You both have a 100% use and enjoyment of the property, even though it may be the income and liabilities may flow 50-50. And consequently, which means that the creditors of one joint owner can completely capitalize on the asset, and the innocent co-owner could actually lose their investment. So not only is it bad from an estate planning point of view, it's also bad from an asset protection point of view, which was a subject matter of our previous discussion. There also can be some unintended gift tax consequences when you're actually creating a joint tenancy. Well, you've actually given an asset away over to a third party, whether family members or otherwise, and that could trigger some gift tax consequences if that dollar value exceeded $15,000, that is as of the year 2020. And then one of the things that we use, which is a big takeaway from all this, is an LLC holding company. Again, from the previous discussions that we had, LLCs really are the primary ways of holding rental properties, sometimes residences, sometimes not, depending upon how it's structured, but typically for rental properties. And inside the LLC operating agreement or in the limited partnership agreement, we have ways of transferring those interests as divisible interests or to be recaptured as far as a right of first refusal within the other co-owners of that LLC or that limited partnership. And not only is it good from a liability point of view, also from an asset protection point of view, and from an estate planning point of view. So definitely the proper way to do it. Joint tenancy, like I said, it's good, it's effective, but it could be very dangerous if it's not used correctly. The other form of will substitute has to do with contracts, and this goes back to my life insurance policies and my retirement plans. And this always a big trap for the unwary, simply because whoever's listed as the beneficiary, they're the ones who are going to receive the assets. It doesn't matter what your estate plan says. And I use a very simple example on this. That if basically you have an estate plan that says between my three kids, a third, a third, a third. And this say it's a second marriage, for example, to kind of make it real. This is actually a real situation I dealt with. And on the life insurance policy, they actually listed the former spouse. Let's say it was Marianne. Marianne was the actual beneficiary listed. Well, that relationship dissolved. They started up a new family and then new wife and new children. And they never updated the insurance policy. And they're all moving along, assuming that should I pass away, of course, I got this $1 million of assets going to pour in for the benefit of my surviving, my now spouse and my kids. Well, the owner passes away, and guess who got the insurance policy? The money. The money went up to Marianne. It didn't matter that the plan said to my three kids, a third, a third, a third, because now you had an asset that was inconsistent. It was going this way rather than this way because the assets and the planning were simply not talking to each other. And the same thing applies over with retirement assets. Again, my biggest offenders here, this happens to be school teachers. I think it's just because when they get out of college, they join the teachers union, they sign up for the 403B plan, they list mom as number one beneficiary. If not, they list their sister as a contingent beneficiary. And then they spend 30 years educating our children, and then they pass away. Now they're married and they have their own children. And all of a sudden, when they pass away, who is the listed number one beneficiary? Mom. Mom is predeceased. Number two is the sister. And the sister, in this case, was a bankrupt drunk and she hates her brother-in-law. So here again, another example where the retirement funds went off to a different direction and left the spouse and surviving children without the use of those funds simply because the contract said one thing and the estate plan said something else. And so I always say when I give these estate planning talks, if you get one thing out of this entire talk for the next hour, go back and look at the beneficiaries of your life insurance policies and look at the beneficiaries of your retirement plans. Because most of my clients have three categories of large assets. Their residence, life insurance policies, and retirement plans. And you want to make sure that those assets they're jiving with your estate plan. You want the beneficiaries done correctly, and then also the real estate as well. So again, very, very important that the assets and the planning are talking to each other. So here again, another example of an unintended disinheritance. So the need for estate planning that we look to find the financial burdens that can be solved, settlement issues, okay, as far as probate fees, again, that varies based upon state, attorney's fees associated with that, estate taxes, that's gonna be something we're gonna talk about. And then we have to worry about improperly arranged estates. So you have insufficient liquidity, and this is going to be a big deal with our property-related expenses. Unintended disinheritance, we just kind of spoke about that a little bit. Unintended trust fund babies, simply create this dumping a whole bunch of cash onto somebody who doesn't have the financial maturity really to deal with it. They didn't have to earn it and don't really respect what it provides for them. And then based upon their age or their influences, that money could be used to their disadvantage. But regarding property-related expenses, let me go ahead and just address that, because we are talking to a property owner group, and this comes up a lot where there's the parents want to leave a legacy property or an apartment property or an investment property over to their kids, but the kids not understanding that the kids themselves may not want it. Or as a result of that transfer, there may be new expenses or taxes associated with that property that the kids simply can't afford to do. And so as a result, you have insufficient liquidity on how to deal with those legacy assets. You're forcing a buyout between sibling and sibling. That may cause its own set of issues, or you may wind up as having a sale or a fire sale of an asset, which really wasn't what you intended. So you want to make sure that when you're planning with real estate and you tend that real estate to go down in successive generations, you want to make sure we have sufficient liquidity to pay for taxes and expenses and utilities of those assets as well. Again, another very important factor for real estate owners. Now, it's kind of crossing over to the COVID issues. This has become one of the hottest topics right now, at least in my office, and this is dealing with powers of attorney for healthcare and property management. These are dealing with documents of incapacity. And over 20 years, I always go down and say that these documents, the powers of attorney for healthcare and property management, are the Rodney Dangerfield of estate plan documents, simply because they get no respect. Everyone's always worried about who gets my stuff when I pass away. Everyone's always worried about the guardians. All that stuff is very important, but they're all thinking about post-mortem transactions. But what I always want to tell my clients is that don't forget that the big part of this planning is also for your benefit. Who takes care of you if you can't take care of yourself? So getting back to what I said earlier, sometimes your estate planning, your administration may take 6 months, it may take 18 months before you actually have a netting out of the estate, setting up some big accounts, and it's kind of on autopilot for the beneficiaries. But if you get into a car accident, God forbid, now all of a sudden you become incapacitated. You may be incapacitated not for 18 months, but for 18 years. And who makes decisions for you? No one's passed away yet, so there's no assets being transferred to the next beneficiaries. The question is now, who steps in your shoes and makes decisions for you? So you have to look at it from a property management perspective, and you have to look at it from a healthcare perspective. And property management is becoming a really big deal. So not only is it, I look at elderly parents, it's always one of the things that we worry about, because I get calls every once in a while and says, Brad, you know, my mom is in a care facility, and she's getting demands from this new relationship. She wants to start sharing money or paying the bills of her newfound friend. And so we're always worried about are we able to protect an elderly parent from themselves without the need to go into a conservatorship, without the need for the embarrassment, the public exposure of these types of issues, worrying about hoarding problems, undue influence issues. We want to be able to step in the shoes of our parents and be able to take care of things for them without basically requiring them to go through all of these legal procedures of getting a conservatorship put over them. Impact on business, that's huge. And that kind of ties into my next point as far as a limited power of attorney. regarding COVID issues. So I always like to use myself as an example here. I know, my wife and I, she's great for everything, right? She takes care of the bills and she helps pay for the taxes, and she manages the household finances, and she makes sure that the investments are going well. But she doesn't know the first darn thing about running a law firm. My father, who's actually my partner of the firm, well, of course, if I become incapacitated, the best person to make decisions regarding the law firm is not my wife, but it's going to be my father. But I don't want my father involved in my daily activities of managing my finances and my retirement planning and filing my taxes. So when you have a general power of attorney, it applies not only to all of your normal mundane assets, but typically also accounts for any business interest that you own. And so sometimes you may want to carve out a limited power of attorney for a particular asset. And again, in my case, a limited power of attorney regarding Barth Calderon. If not Brad, then Harry Barth, my dad. But the general power is everything else as my wife, excluding Barth Calderon. So I also have one with my dad. Like right now, my dad, he's 73 years old, and thank God he's healthy, but he basically is self-quarantined. He's one of these high-risk individuals, and my father hasn't left the house in 4 months. So who do you think is doing the banking on his behalf? Who do you think is negotiating with the landlord at the lease on his behalf? It's not him, it's me. And I'm doing this by way of a limited power of attorney on behalf of not only my dad on the personal banking side, but also on behalf of Barth Calderon. So another example where a business partner is the best person to manage a particular asset, especially in this type of environment, where my mom is the one that's taking care of all the everyday finances and retirement plannings and investments and paying the electric bills, et cetera. I don't need to get involved in that. Let them, I will take care of the one asset. And this is becoming a really big deal in light of COVID because everyone is kind of self-quarantining. Also, in the same vein, if you're incapacitated, who's going to make medical decisions for you? Here in California, we call it an advanced healthcare directive. It includes a very important provision that not only nominating individuals to make medical decisions for you, but there could come a point in time where you say, well, I don't want to receive medical care, right? If I'm in a medically determined irreversible coma, I'm effectively in a permanent vegetative state, and all you're doing is kind of artificially delaying the moment of my passing by keeping me plugged into these machines, which is causing economic hardships. It's causing emotional hardships. Some people, well, the majority of people, under those circumstances say, listen, remove the intervention. Let my body do what it's going to do. However, I still want to receive enough medical care for my comfort and to alleviate pain. Call it the companions. Let me go, but don't let me feel it. You got to put that stuff in writing. We have to have clear and convincing evidence. So in other states, it's called a living will. Don't confuse it with a last will. A last will and testament is different than a living will. A living will is what we refer to as the pull the plug provision. Very important provision. If you ever want to see the circus, just look up the old case of Terry Schiavo back in Florida, and that will kind of bring back nightmares for some of us. We also want to address your final wishes and arrangements. What about making anatomical gifts, for example? So if you are an organ donor, and people have, like here in California, we put a little pink dot on our driver's license. When I normally ask the next question about being an organ donor, says, well, does that mean that you also want to be a teaching cadaver at the local medical school, or do you want to help humanity by donating your body to science? That's being an organ donor. They're like, nah, what I intended was if I help another human being directly, like someone needs a liver, or a heart, I'm okay with that as a human being directly, but I really didn't intend for institutional beneficiaries. Okay, well, let's say so. Let's go ahead and put that direction inside there so the agent knows how, because typically at that point in time, it's very difficult to have a conversation. What did you mean when you said organ donation? Also, regarding final wishes and arrangements, for some people, it's burials versus cremations. There's religious issues. There's certain places. There's certain people they want to acknowledge. So you want to make sure this stuff is all kind of written up inside the documentation, because you want to give people notice and instructions on what you want to have happen. And also a very important deal here is also with the long-term care provisions, because I find that this is missing from a lot of documentation. And one of the great things about here in California that we actually have very good documents in this regard. And probably about 2007 and 2008, our government went to work and came up with some very good provisions regarding long-term care. And so here, a basic statement should be said that if I require long-term care and if that care can be delivered to me at home, it's my preference to stay home, have that care delivered to me as long as it can be done without endangering my mental or physical safety. Okay. And if I do require care, I want to be in a facility that's the least restrictive, it's the most home-like setting, it's close to friends and family, it has outdoor activities. I want to return home as soon as possible, right? You got to put this stuff in writing. Otherwise, you literally can have someone just putting you in a home and kind of forgetting about you. And I've seen this where the kids are more concerned about protecting and preserving their inheritance. They're not putting a lot of dollars into the care of mom and dad. It's very sad. You want to make sure you have some documentation that kind of spells out what you want, so we have a way of enforcing what those provisions are. Again, very, very important documents. The next one, of course, is with us that have minor children. I have a couple of minor kids. I have 4 kids. I have 2 adults. I have 2 minors. And so here, this is probably one of the most important decisions that most people need to make. And my oldest daughter is 21 years old, and my youngest right now is 6. And my wife and I, for 22 years, have been arguing about who the guardian should be, because we're concerned. I mean, who better to raise your kids than you? And it's difficult because it's not just, oh, my sister. Because along with your sister comes your brother-in-law, right? Love your sister, brother-in-law, not so much, right? But you have to worry about putting your children into somebody else's household. Do they share the same type of socioeconomics that you're trying to raise your kids in? I can tell you, over the years, I've moved into different cities to create a better environment and better school districts for my kids to be able to grow up in. Religious issues. I'm a religious guy. I have my kids in religious school. I'm involved in the religious community. So the people that I choose for guardians are important that they also have similar type of religious foundation. So that's important also. In-law issues, I call it outlaw issues. You know, like I said, love my sister, my brother-in-law, whatever, or I love my brother-in-law, I don't love my sister so much. So it's important on who the best person is, and geographical issues is another big deal. You know, you have children that are growing up in a certain environment, and they're involved in the community, they're involved with the church, they're involved with the Boys and Girl Scouts, and they have their school friends, and all of a sudden something happens to mom and dad. And I've seen this where they're picked up and they're moved to different countries. They're picked up and they're moved across the country, and all of a sudden they lose their social structure, their entire support system, and now they're put into some strange environment because, oh, just my sister should be the right one. Sometimes the guardian may be your best friend. It's the person that you hang out with on a regular basis. So give that some thought, a very, very big deal. And not to mention the economic hardships. As I said, I have 4 kids. They're already an economic hardship on me now. But if I take my kids and plop them into somebody else's house, it's certainly going to be an economic hardship on them as well. So I don't want my guardian simply to say no, because I can't afford, thanks but no thanks, I can't afford to take care of your kids. So I got to make sure I have enough liquidity in my estate to be able to provide for them. I want you to have custody and guardianship over my kids. I don't expect you to pay for my kids. I will pay for my kids. That's my responsibility, either by way of having the assets in your estate or manufacturing the assets by having an appropriate life insurance policy or policies. And who do you manage to do all this stuff? Again, who do you trust? And again, I'll use my sister. I'll give my sister my kids, but I won't give her my checkbook, right? And so I call my sister the golden heart and the empty head. Love her. She's a great person, but she's terrible with money. So here I may wind up giving somebody else to be the financial guardian, my father, for example, but then I give my sister will have physical custody of my children because, again, she's probably the most appropriate age. I think my dad at 73 and my mom at 73 are not really to take on a 13-year-old and a 6-year-old at this point in their life. They were my guardians at one point. They're not now. One of the benefits of having an estate plan while you're alive is that it's transitory. It can completely be changed and modified during your lifetime. Guardians, healthcare agents, people making decisions regarding your finances, when you wind up putting people on as fiduciaries, especially in the guardians, you wind up looking at them from a very different perspective. we've had different guardians throughout the years. And when you notice somebody and you go to visit their home and you're there for a weekend, you're like, maybe we should reconsider this choice, because look how they're raising their kids. Not quite what we had in mind. So again, you start looking at people differently, but if you don't have the documents, you're just simply relying on the state documents to appoint someone, or they'll figure out amongst themselves, it may not be the best choice that you would have chosen or had an opportunity to kind of look at it from that perspective. So it's an important thing to take into consideration. And how are all these issues resolved? A lot of them are resolved with the use of a living trust. It helps to control distribution. Now we can manage fees and taxes, very much different than a probate. We can have professional management, which prevents that trust fund babies and other types of inappropriate use of the funds. And then here we can avoid probate. How does a trust avoid probate? You hear this all the time. Have a trust, avoid probate. The question is, how does it happen? It happens by having all the assets funneling in or properly titled in the name of the trust. And so here, by the trust, I always say, is just think of it as an empty shoebox. And that shoebox is empty until you put stuff in it. When you put stuff in the shoebox, you've already determined who the beneficiary of that shoebox is. You've already listed the successor trustees. You already legally empowered someone to have custody of the assets, manage the assets, and then to distribute the assets to the beneficiaries. We don't need the state to do anything. We don't need probate. You've already affirmatively done that, and you empowered them through the legal document to do so. That's called the trust. But you got to put the assets inside. And so part of the recurring housekeeping, and why this is a very important slide, is that people will come to me in 2020, will create their trust, will fill up their shoebox with their house, their business, their bank accounts, their life insurance, retirement, will do all the appropriate funding. Then 3 or 4 years goes by. Well, they sold the house and bought a new house in joint tenancy. They closed up the account and opened up a new account at the credit union name in their individual name. They switched over broker. They have a new retirement plan listing somebody else as the beneficiary. Maybe they got a new life insurance policy and they listed their spouse directly as the beneficiary. And at the end of all that, what's inside the shoebox? Nothing. So although we took all the time to create asset protection provisions, multi-generational provisions, charitable considerations, it has no assets because everything else is flying in these different directions because there's nothing inside the box. And to boot, we're going to have a probate. But if the trust is properly funded, we minimize probate expenses, not only in your home state, but again, in every other state where you own property. So back to my earlier example, I have a California trust. My house that I'm sitting in is inside my trust. My property in Nevada, inside my California trust. My Florida property, inside my California trust. My Texas property, inside my California trust. So now when I pass away, I don't have any ancillary probates in those states and no probate here in California. It makes the funds immediately available. I'm not waiting for courts, especially in this COVID environment. Who knows how long it's going to take for the backlog for people to get through the whole probate process. In the meantime, there could be all kinds of needs and businesses and decisions have to be made, and it's all tied up in probate. I can give you nightmare story after nightmare story of things that happened in probate and the disasters that it's caused from a business point of view and the children needing money point of view. But again, beyond the scope of today's talk, and you also get to minimize your attorney's fees and your executor's fees. You're still going to have accounting issues and appraisals. There's still a cost associated with administration, but you certainly minimized it a lot. Now, let's talk about some taxes. This is the other part of the death and taxes. Now here, President Trump signed back in December 22nd of 2017, the Tax Cuts and Jobs Act that became effective 1/1/18. And what is the bottom line on that? The bottom line for most people is this, is that the personal estate tax exemption is now, as of 2020, $11.58 million per person. And then every dollar above that is set at 40%. So now this is on your net estate. So again, this is why estate taxes really isn't an issue for the majority of Americans, because not everybody has 11.5 million at an individual level. And if you're married, the second bullet point is that any amount that one spouse doesn't use, the first spouse to pass away of their 11.5 million, gets ported over to the surviving spouse. So you take 11.5 and you add 11.5, you got $23 million for majority of married couples in the country. And so here again, it's not that big of an issue for most people. But business owners and property owners, and now you start chunking in some life insurance, now you may breach that 11.5 at an individual basis or the $23 million at a married basis. And once you breach that threshold, the tax rate is 40%. Now, as I mentioned earlier, there may be additional state tax rates that are different. Maybe there's a smaller exemption amount. Maybe there's a different amount that's paid on top of that. I'm only talking about federal estate taxes for purposes of this presentation. So here you have to be aware of this, because what may happen in future administrations is that $11.5 million exemption may drop down. As a matter of fact, look what I have in red. The Trump law is automatically set to expire as of 1/1/26. So although he was able to bump it up to 11.5, effectively doubling the Obama exemption, he wasn't able to make it permanent. And so here you have two parallel systems going on. You have a Obama level here that's being adjusted for inflation and the Trump numbers. And when Trump just goes away, it now just reverts back to the Obama numbers. And what's the Obama numbers? Roughly about $5.5 million. So you're going from an $11.5 million per person to a $5.5 million per person. And everything above that is going to be subject to 40%. And I've seen commentary from my colleagues where it may get dropped down to $3.5 million and not 40% above, 65% tax above that. So they're going to reduce the threshold and then meddle with the actual percentages above that. And I say to myself, well, look what's happening with the government printing money in this COVID environment. Some way they have to get that money back. And I always say that dead people don't vote. And this is just one of those areas where the government is able to go in and grab money from people because people aren't paying attention to this. They're all worried about the income tax benefits, and they're not paying attention to is what the estate tax implications are. So right now we have a wonderful estate exemption, and we have a great opportunity to do a lot of planning to get assets out while we have this $11 or $23 million corridor, so that if the exemption amount is reduced, you've already got the assets out. We call that estate freezing techniques. How do we get assets out so your estate doesn't just continue to accumulate? Because the larger your estate, the more taxes that you're going to have to pay. And so we always take a look at that. And so a lot of our clients back pre-2018 would have what's called an AB trust. I'm not going to get into the details just for time purposes, but what we're seeing a lot of nowadays between married couples, same biological children, long-term marriages, that they're modifying what's called an AB to an A only. And I'm sorry for the technical language here. So just for time purposes, they're simplifying what the surviving spouse is able to use and enjoy without the need for separate accountings and irrevocabilities and separate tax returns, and keeping what most people would think. When one spouse passes away, it's just held for the benefit of the surviving spouse. We still use AB trusts for asset protection reasons. We still use AB trusts for purposes of highly appreciating assets. So we still use that, but for the majority of people, we go back and we take a look at whether or not an AB split is necessary. And here again, we also use it in cases of blended families. So if you do have a blended family, which now is representing about 50% of my client base, well, what you're saying is that I have a child, I love my kids and she loves her kids, and we love each other, but I don't love her kids and she doesn't love my kids, and the kids don't love us. And I call that the evil stepmom and evil stepdad problem. And depending upon the age difference, the kids could be waiting a long, long time for somebody to pass away before they're able to receive an inheritance. So here we're able to still use an AB arrangement where we're able to split the assets in between so that it's protected for a surviving spouse, and it's also protected for the decedent's children. You can have, I love you, honey, you get to have some income in principle, but when you pass away, I want my stuff to go down to my kids, or some variation thereof. So it's very important that we still use these AB splits for purposes of blended families. Again, it's not a tax-driven decision. This is more a family dynamic driven decision. Very, very powerful, very, very important. So just some really quick math here. This is some lawyer math. So the new exemption right now is $11.5 million, a single exemption, so a single individual, assets at $10 million, life insurance at $3 million. This is just an example showing you that because the insurance is inclusive, my estate size is 13 million, not 10 million. And as a result, you take out 11.5, 40%. This is resulting in a $600,000 actual tax. But if you look at the assets are actually less than the exemption, right? So what's causing $600,000 of taxes is the life insurance policy. So thankfully, the government has given us some tools where we can start to reduce our state tax exposure. And this is why I kept on going back, life insurance, life insurance, life insurance, because we have a tool. It's called a life insurance trust. Uncle Sam acknowledges the very important need for life insurance, but we also want to make sure it's available and not being taken away. I don't want Uncle Sam being a 40% beneficiary of my insurance. I'm not paying a premium for Uncle Sam's benefit. I want that money there for the benefit of my family, for the benefit of buying out my business, for whatever the benefit is that you got it. I want to make sure it's there. So there's a tool called a life insurance trust that keeps the death benefit outside the taxable estate. And as I keep on saying, it may not be an issue for you now with 11.5 or $23 million, but if that exemption goes down as it's being proposed to $3.5 million, I can tell you that the majority of my clients here in California, a piece of property, a 401k plan, and a brokerage account, and maybe a business, $3.5 million exemption is nothing to what their overall net worth is. And then you add life insurance on top of that, all you're doing is just paying money into the federal government's benefit. So you got to create an irrevocable life insurance to protect and preserve those death benefits. And on top of that, the money that's inside this thing also gives us a liability shield. And if you remember from my previous conversation about asset protection, we're always worried about what personal assets do I have that are exposed to my creditors. And again, every state is different. The majority of the states protect cash value of life insurance, but places like here in California do not. And so if my clients get nailed in a lawsuit for whatever reason, car accident, whatever, I don't want the cash value that they're accumulating as part of their quasi-retirement financial planning needs to be taken away by a creditor. So now I'm looking at a life insurance trust for two purposes. I'm looking at it to minimize the estate tax exemptions, and I'm looking to protect the cash value from the claims of my clients' creditors. So again, we get a double dip here with this very, very powerful estate planning tool. There's also forms of gifting trusts. So here again, the way that you minimize your estate tax exemption is I call it the three-legged stool. You use insurance, gifting, or insurance. Any one or all three of these. So we just talked about the use of insurance to pay taxes. You can use gifting, and there's various ways of gifting. There's straight gifting trust. There are forms of what are called grats. There are idiots. There are all kinds of ways of actually getting property out of your estate. And there are ways of doing it in a way that you don't just gift assets away and basically disinherit yourself. I got plenty of clients that want to give to their kids, but they still need the income that asset is producing. They're living on the income off that asset, but that asset is also appreciating and causing an estate tax problem. How do you marry that? So there are very specialized tools called idiots and grats and other forms of even charitable devices where we're able to get the asset out of the estate, let it grow out of the estate, completely asset protect it, all the while retaining an income stream back to us. Again, it's a little bit more of the advanced class, but I want to let you know that these tools are available, especially in the real property heavy owned estates. Also, on a recent development I wanted to share with you is retirement funds. I certainly can't talk because this ties into what's happening with the Secure Act. But one of the big things I always want to point out is this landmark case that came down in 2014 with the Supreme Court called Clark v. Raymaker. And most of my clients, and you may even remember me talking about this in a previous discussion, that retirement plans are asset protected. Absent a federal creditor, the substantial majority of our 401k plans and IRA plans, again, state dependent, are going to be protected from our creditors because the government wants you, encouraging you to put money away for your retirement. And they want to provide protections over that. So the first time you get into a fender bender, the plaintiff's lawyer doesn't take your retirement away. If they take your retirement away, you're going to become a ward of the estate, when you no longer are able to work. So they want to make sure that those funds are protected. They created these very powerful ERISA, Employee Retirement Income Security Act, anti-alienation and spendthrift provisions to protect your retirement plans. But when somebody inherits that retirement plan, it now loses that protection. And that was the holding of Clark v. Rainmaker. It's protected for your retirement. It's not protected from the claims of an inherited beneficiary. It's not their retirement plan. All the need to protect it for the retiree, not for the beneficiary. It's just a fancy bank account that has some deferred, tax deferral. So that was a big deal. And how do we now protect our inherited assets? We now have to turn to other devices such as an IRA inheritance trust, some type of trust to give us retirement protections. As I said, 3 large assets: a house, life insurance, and retirement. So if you got a 401k plan that's got $1 million in it and you pass away, that $1 million doesn't go part of your trust. It typically goes straight to your kids. Now, we may have done a bunch of other stuff to protect your kids and stuff from their creditors, but the retirement plan goes to them directly because the advisor said, let them stretch it, let it go to them, let them get the benefits of it. But all of a sudden now it's theirs. And because of Clark v. Rainmaker, that is now subject to the claims of their creditors. So we want to avoid that by continuing to protect the inherited IRAs by way of these IRA inheritance trusts. And we have to be aware because, as you all may know, there's a brand new thing called the Secure Act, which took what used to be a nice lifetime RMD distribution for the beneficiary's lifetime, now says it has to be distributed in 10 years. They call it the Secure Act. I'm not quite sure whose security. I think it's the federal government's security. It certainly isn't my Security Act. So definitely caution, taxes are ahead. So you've got to find some other device where we can protect those tools, hopefully beyond the scope of a 10-year time period.
Well, we're approaching 12:30. We still have a lot of questions. I think, they're really good questions. So I'm definitely going to send them to you, Brad, to
Sure.
follow up on.
Sure, thank you.
And then, of course, again, one more time, we are going to give everyone the recording. I still have the link in the chat if you do want to schedule something with Brad. And with that being said, Brad, thank you so much for coming on. This is fantastic. So much information.
I apologize for the rapid fire, but I wanted to get a good spectrum of information to the audience, and hopefully that's why we had that time. Any questions on the materials, feel free to reach out and we can explore those items in more detail. Okay?
Absolutely. All right, everyone. Take care.
Okay.
Have a great day.
Thanks a lot. Bye-bye.
Bye.